You're going to want to watch this next video in its entirety because it is about a letter that a federal judge wrote, a very blunt letter that he wrote about the Supreme Court to the Supreme Court, chastising them for the recent decision, not just the decision, but the thought process, the timing, the whole thing. He's very blunt in his criticism of the Supreme Court, excluding Alito and Thomas. Those two gentlemen he agrees with. But as far as the rest of them, including the rhinos on the Supreme Court, he has some very choice words. So watch it in its entirety. It'll hopefully give you some faith in our judicial system. And I'm imagining you, like me, are quite frustrated with some of the decisions, not just from the district court judges, but of course from our own Supreme Court. Take a listen. You'll enjoy it. Here you go.
The Supreme Court gets shredded by the Fifth Circuit. We've spent a lot of time on this case, the AARP WMM FGM case. And this, of course, is just a list of acronyms, pseudonyms for illegals who are not required to use their real names, because if we use their real names, then we'll know that they're like Kilmar, and there could be problems for their cases if they bring those and we're able to discover all of that problem. But here is what is coming out of the Fifth Circuit. Now, this is in response to what the Supreme Court said previously. If you recall, earlier this week, we read through a decision, or maybe was last week, on May 16th from the Supreme Court of the United States. And the main crux of this, really we saw in the dissent. And if you recall, it was about deporting people out of Texas. And what happened was there was a lower level district court judge who said that the deportations essentially could happen. The ACLU came back down and their gangbang lawyers, and they sued and they said, this judge, you better respond to us within like 45 minutes because they're putting them on an airplane and they're about to deport them like right now. They said it's an emergency and it's an emergency. And the Supreme Court bought that, right, and scolded the lower level judge. It said the Fifth Amendment entitles illegal aliens to due process when it comes to removal, and the government is saying that they can remove these people. But under the circumstances, 24 hours is not enough. And they laced into the lower level judge. It was very inappropriate. When we read through this before, we were very unhappy about this because it was inappropriate for them to do that. And the application for the injunction was granted, and the Fifth Circuit is going to get this case back. And Judge Alito was very unhappy about it. Now, what has happened is this judge is named Judge James Chuen-Yu Ho. He's Chinese, and he was actually born in Taiwan, actually. I guess his name is Chinese. Now, he's in the Fifth Circuit, and so he is a foreign-born judge. And we often rip on foreign-born judges because we wonder why we can't have domestically born judges. It's always curious to me. They can't find somebody from like Pennsylvania or someplace who's going to be a judge on that court. Anyways, this judge came out and gave us a good opinion today, and it's absolutely accurate because it blasts the Supreme Court. And here is what Judge Ho said in response. So remember, Supreme Court gets this case. They scold the lower level district court judge, say you should have acted more quickly. You acted, took 14 hours or whatever it was. And now they have to solve this. The Supreme Court punted this, gave it to the Fifth Circuit and said, you guys decide this. We don't really have, I guess, the capability of doing that. So why don't you guys figure it out? And here is what the very short order from the court of the Fifth Circuit has come out and said. They said last Friday, the Supreme Court vacated the judgment of our court. We already heard this case. The lower level district court dismissed the case, then they appealed it, and the Court of Appeals dismissed the case because they said, how dare you demand that the lower level judge act on your timetable? And they dismissed it. But now they say the Supreme Court remanded the case back to us and directed us to proceed expeditiously, whatever that means. So accordingly, this matter is expedited to the next available randomly designated oral argument panel, which will be coming soon, right? So not much there. In other words, the Fifth Circuit is catching the ball that the Supreme Court kicked over to them, and they'll get it scheduled. Now, the real decision comes from James C. Ho, and he's filing this in a concurring opinion. James Ho obliterates the Supreme Court in this, and they deserve every bit of it. He says petitioners who are identified as gangbangers, members of Tren de Aragua, a designated foreign terrorist organization, should not be allowed to proceed in this appeal. Now, he's going to concur in this because he's ordered to by the Supreme Court. He's saying this is ridiculous. On April 18th, from our court, we issued an order from the Circuit Court of Appeals in Texas that we lack jurisdiction to grant the relief sought by the gangbangers. But then, on last Friday, the Supreme Court reversed our unanimous decision over a vigorous dissent by Judge Alito that we read through here that was joined by Judge Thomas. Now, as an inferior court, we're duty-bound to follow Supreme Court rulings, whether we agree with them or not. And we don't have to like it, but we have to do it. So I concur in our order today, expediting our consideration because the Supreme Court told us to. But I write to state my sincere concerns about how the district judge, the lower level judge, as well as the president and other officials have been treated in this case. And I worry that the disrespect they have been shown alone will not inspire continued respect for the judiciary, without which we cannot function. This is the same argument we've been making here forever. John Roberts, by being a little pansy with the rest of them and not coming out and giving us clarity on this, is undermining the credibility and the legitimacy of the court, which is to their own detriment. So it's like, well, we're going to avoid a conflict here. We're not going to wade into this political mess. And by doing that, the justification being if we wade into that, we're going to undermine the legitimacy of the court. And then by not wading into it, they're destroying the legitimacy of the court. The judge writes, Judge Ho, it is not the role of the judiciary to check the excesses of the other branches any more than it's our role to check the excesses of any other American citizen. Judges do not roam the countryside looking for opportunities to chastise government officials for their mistake. That's not what we do. Rather, our job is to simply decide those legal disputes over which Congress has given us jurisdiction. And under the law, U.S. Code, appellate courts have jurisdiction, the law says this, to review interlocutory orders of the district court when they refuse to enter an injunction. Now, that includes orders that have the practical effect of refusing an injunction, which is what the Supreme Court basically said happened here. Now, that is demonstrably not this case. The Supreme Court made it this case. They cited that stuff to kind of make it fit, but it's not at all. The district court, writes Judge Ho, made ably and amply clear to the gangbangers that it stood ready to hear their request for emergency relief. Indeed, the court had already ruled on such requests the day before. Like the judge was doing his job. The court simply advised the gangbangers that the government would get 24 hours to respond before it would issue a ruling one way or another. We got to hear from the other side before we take action. Now, the lower court also reminded the ACLU that the government had assured the court that they're not going to remove these people without first giving the court advance notice. So the government has told them, your petitioners that are a party to this case will not be afuered, okay? So just chill out. So when the gangbangers came and they sought emergency relief at 12:34 a.m. on April 18th, midnight, right in the middle of the night, the gangbangers were fully aware that the district court intended to give the government 24 hours to file a response because the court has already said that. They said nothing about a plan to appeal this if the district court elected to wait for that response, right? At a prior hearing, they said, okay, 24 hours, fine. So then at 12:48 p.m. on April 18th, the ACLU suddenly informed the court. They said, hey, we're going to file an appeal if the district court did not act within 42 minutes. That was at 12:48 p.m. So we've got the emergency relief comes in at 12:34, so like midnight, right? Judge should be asleep. Then at 12:48, they say, hey, we haven't gotten anything from you. So it's been like 4 hours, maybe 5. Court opens 8:30, right? Then it's 12:48. They send in another motion. Hey, judge, if you don't respond to us within 42 minutes, because we already filed at midnight, and now we waited like 4 hours since the court opened. If you don't act by 1:30, then we're going to appeal you, punk. So when the court, to no one's surprise, couldn't comply with their patently unreasonable timetable, petitioners immediately filed this appeal. So they left the lower district court of Texas and came up to the Court of Appeals, which is where we are now. And so our court in the Court of Appeals, we also responded expeditiously. That night, in fact, we held that we lacked jurisdiction to hear this case. And our order explained this. It said that the gangbangers gave only 42 minutes to act, and they did not give the respondents any opportunity to respond. Now, as our distinguished colleague put it in the Court of Appeals, right? He's saying my neighbor here, who's also unanimous in this, they say 42 minutes is quite plainly an unreasonable deadline. It says we cannot find an effective denial of injunctive relief based on the failure to respond within 42 minutes. Like, we're not obviously going to do that. We're the court, we're the judge, not the gangbangers. And the gangbang lawyer also called, remember, and scolded that judge, left a voicemail on his voicemail and said, I need you to act right now. Wake up, get out of bed. My illegals are in trouble. Now, the Court of Appeal says our decision was unanimous because it's obvious, right? 42 minutes is not remotely enough time to review and analyze all of the relevant legal authorities and prepare a reasoned ruling. And notably, the justices themselves have expressed concerns about making decisions under far more forgiving time constraints than those demanded here, right? In other words, the Supreme Court has said, if you act too quickly, that's going to be a big problem. And acting too quickly in those cases was much broader, like much longer time. Recall that there was emergency relief sought in this case back in 2021. He says, remember this Supreme Court, in case you guys forgot, it was called Doe's 1 versus 3 versus Mills. 2021. Members of the Supreme Court expressed concern in that case that the use of the emergency docket to force the court to grant extraordinary relief on a short fuse without the full benefit of the briefing is a big problem. And who wrote that one? Oh yeah, Amy Coney Barrett did, remember? So Amy Coney Barrett, if it's somebody else suing Doe's 1 through 3, she has a meltdown. Wow, this is ridiculous. We can't use this emergency docket to force the court to act within 42. Ridiculous. We're not going to operate here on a short fuse. We want everybody everybody to have the full benefit of a full briefing so before it gets to the Supreme Court. Unless it's alien enemies and terrorist gangbangers, and suddenly they're like, oh, it's an emergency, and everybody pops out of bed to issue a stay. Now, the amount of time considered too short in the Doe's case was 9 days, right? Amy Coney Barrett, back in that case, in her concurring opinion, she denied the relief in that case. She said, no. 9 days? Like, you're coming to us after 9 days? That's ridiculous. That's way too fast. You need to go brief your stuff, go through the courts, and then come up to the Supreme Court, then we'll hear it. But now it's 42 minutes, and that's too long. Malpractice for this district court judge to allow that to happen. He says, compared to 42 minutes, however, 9 days is a lifetime to decide a motion. And they didn't allow that to happen when it was 9 days. They're like, it's way too fast. Slow down. So the district court in Texas reasonably assumed that the principle invoked in the Doe's case that came from the Supreme Court, where you said 9 days is way too fast, to justify denying relief to law-abiding citizens concerned about their religious liberties in the COVID-19 era would likely justify denying relief to illegal alien members of a foreign terrorist organization. Oh, that's savage, man. Amazing, right? So Amy Coney Barrett, if you're a law-abiding citizen and you're concerned that your religious liberties are being violated, and you file to say, please stop the government from abusing my First Amendment rights as an American citizen. Court, act quickly. Stop it. I'm about to be fired. We're going to lose everything. Our whole business is going under. Amy Coney Barrett and the justices said, well, we need full briefing before we can consider your rights. You're an American citizen? Get in the back of the line. No one cares. But when it's an illegal alien Tren de Aragua putative class who's allowed to proceed pseudo-anonymously in our country, you can see if you can get charged with a crime or proceed pseudo-anonymously on anything. And the answer is usually no. But they get protections because they get more due process, more rights. It's premium America if you're an illegal alien. Don't need a driver's license, don't need insurance, can traffic humans, beat your spouses if you want to, no one cares. And if you're about to be removed after the American people voted and elected a new administration to come in here and clean all this stuff up, you're about to get deported, Amy Coney Barrett has a meltdown, pops out of bed, joins all the other ladies on the Supreme Court and says, this is egregious. We have to stop this now. The district court was absolutely right, writes Judge Ho, when it noted that issuing a competent and defensible ruling, like the Supreme Court dictated to us back during the COVID era, it required some level of care. And it takes some level of care. It takes time to do that. And so Justice Alito noted in his beautiful dissent that we read, he said, we should commend this careful approach and not criticize it. But rather than doing that, Judge Ho writes, rather than commend the lower level district court in Texas for actually following what the Supreme Court said to do and give the government an opportunity to respond to this, the Supreme Court charged the district court with inaction, right? And I don't know who wrote this because they wrote it in per curiam opinion because they're pathetic, but it sounds like Sotomayor or maybe Barrett. Says inaction, not for 42 minutes, but for 14 hours and 28 minutes is what they said. And we thought, oh my gosh, they've got George Floyd on the brain. They're doing like the 8 minutes, 24 seconds or whatever that was, the Dave Chappelle routine. So 14 hours and 28 minutes. Well, it's not 9 days. Did you talk to Amy Coney Barrett, who's screaming about 9 days? This inaction, according to the court, was tantamount to refusing to rule on the injunction. And the judge already told them 24 hours. And they called screaming about it and demanded this. So let's explore this because the Supreme Court botched this badly. He says, let's calculate this. If you guys want to do this 14-hour crap, how about this? To get to 14 hours and 28 minutes, says Judge Ho, rather than 42 minutes, the court was obviously starting the clock at 12:34 in the morning, rather than 12:48 p.m., which is when the petitioners told the district court for the first time that they wanted a ruling before the government could respond, right? So they submitted two motions. One was the emergency relief at midnight, in the middle of the night, and then once again, when they didn't get the ruling back like that afternoon. 12:34, give us 42 minutes or else. Now, the clock is off. Starting the clock at 12:34 in the morning, like the pathetic Supreme Court did, not only ignores the court's express instructions respecting the government's right to respond, right? Amy Coney Barrett out of the Supreme Court said, we got to give everybody time to fully brief this matter. And the government told the gangbangers, we're not going to deport your plaintiffs either. So there's no urgency. It also ignores the fact that the court is starting the clock, he says, at 12:34, right? First of all, like two things here. One, Supreme Court told the other courts to respect the government's right to respond. That's a mandate from the Supreme Court, so he's following your rules. But they also filed it at 12:34. So forget all the legal stuff, like don't have to be a lawyer, Supreme Court scholar, went to Harvard or any of that crap. They filed it at 12:34 in the morning. Now we seem to have forgotten that this is a district court, not a Denny's, Amy. This is the first time, says Judge Ho, I've ever heard anyone suggest that district judges have a duty to check their dockets at all hours of the night just in case some gangbangers decide to file a motion that we have to act on. If this is going to become the norm, then we should say so. District judges, say the Supreme Court, are hereby expected to be available 24 hours a day, and the Judicial Conference and the United States Administrative Office should secure from Congress the resources that are necessary to staff and to ensure 24-hour operations are happening in every district across the country. If this is not to become the norm then, which it's not, then we should admit, says James, that this is special treatment being afforded to certain favored litigants like members of Tren de Aragua, and we should stop pretending that Lady Justice is blindfolded. Absolutely right. Same thing we've been screaming about here. Why are they a putative class? Why do they get to have special protections and emergency docket hearings in the Supreme Court of the United States? Why do they get calls to the FBI who let them go when they should be arrested immediately and charged with crimes? Because they have premium version of America. I don't know how much it costs. It's free for them. I don't know why. Well, we don't get it. If you're a COVID person, you got fired because you stood up for your rights. You don't want to do things that are in violation of your religion, and you're a free American for crying out loud, and you sued, Supreme Court didn't give a crap about you. You're just a peasant. Stop killing grandma. Enjoy your winter of misery and death. But if you're a Tren de Aragua gangbanger, man, they bend over backwards to make life amazing for you. Now, the judge writes, I have no problem making clear when a district court has abused its discretion and thereby jeopardized the reputation of the judiciary. In fact, he's saying, look, I've got many examples of this, and I'll go find them, collecting examples. He's like, I'll find this one and this one. He's going to look them all up. But this district court judge in Texas conducted himself in a reasonable and admirable manner. All inferior court judges expect to be reversed on appeal from time to time, but I'd wager that this judge never imagined he'd be reversed on grounds of laziness. And he says, I looked into this judge. A brief glance at the docket suggests an extraordinarily diligent judge who somehow found the time to balance the needs of this challenging case by screaming ACLU lawyers, including a number of motions and orders throughout the week, all while presiding over a complex and sensitive criminal trial involving multiple child victims. Maybe by illegals, who knows? But this judge is handling everything. And they're like, you didn't act in 14 hours. And this judge like had his knee on their necks or something. So any criticism, writes Judge Ho, of this district judge is unwarranted and unfortunate. And I couldn't agree more. We were reading through that. I couldn't believe the Supreme Court was being so aggressive towards him. It's like they're mad at themselves. It's like an abusive spouse or something. You broke that thing. So don't blame him or the Fifth Circuit for this. This is your business. So any criticism is unfortunate. He says it's no wonder that Justice Alito rejected the court's decision, calling it misleading, lying, and a mischaracterization of what happened down there. As he put it, the court characterizes the district court's behavior during the period in question as an action, but he says that's unfair. This judge was working with the utmost diligence to resolve the important and complicated issues presented by this motion as quickly as possible. And moreover, a distinguished former district judge has already come forward with these pointed observations. He's saying someone else said this too. In fact, Paul G. Castle wrote about this in the Wall Street Journal after the Supreme Court came back down and acted a fool. He said Judge Hendricks' service was exemplary. Says the majority was wrong to malign this judge and sent a disturbing message about procedural norms. We need more jurists like Judge Hendricks, and the Supreme Court should think more carefully about how its rulings could distort the work of the lower courts. Yeah, it was very inappropriate of them. It's like somebody who's like a black belt coming out and just beating the hell out of a white belt who did an amazing job, right? And was stellar and outstanding. It was pretty sick to see it. Now, the district judge is not the only public official whose treatment in this case warrants comment. Supreme Court, recall why the district court established the 24-hour filing deadline. Why is this? Because the court firmly believed that the government should have the right to express its position before any ruling is issued, and rightly so. That's how the law works. Our adversarial legal system has long been premised on the notion that judges should impartially consider the views of both sides of any dispute before issuing a ruling, obviously. And Alito commented on this, saying the court took the entirely reasonable position that it would wait for the response before acting, as it's supposed to do. So it should go without saying that the president and his fellow executive branch officials deserve the same respect that courts regularly afford to every other litigant, including other presidents and officials. You guys, the Supreme Supreme Court have given prior presidents the benefit of the doubt, right? Good grace, the presumption of regularity, the benefit of friendship and comedy. Says one former president tried to shame members of the Supreme Court, if you remember this, during a State of the Union address by disparaging a recent ruling. Remember when Obama came out, like lambasted them, seated right there? That same President Obama also suggested it would be illegitimate for the Supreme Court to declare an act of Congress unconstitutional, right? Remember Obama said that if they nuke Obamacare, he's not going to follow it. Peter Walston and Robert Barnes wrote that one. Obama's Supreme Court comment stirred debate in the Washington Post. Now, another former president was also disbarred from practicing law before the Supreme Court. Remember when you did that with Clinton? And see also the editorial saying when Biden ignored the Supreme Court. Remember that Biden said, the Supreme Court didn't stop me. I don't care. I know I'm not allowed to do that, but I did it anyways. Saying American presidents may not like Supreme Court decisions, but most of them since Andrew Jackson haven't bragged about defying its rulings. But Judge Ho wraps it up, says, yet I doubt that any court would deny any of those presidents the right to express their views in any pending case to which they are a party before issuing any ruling. And so our current president, Donald Trump, even if you don't like him, he deserves that same respect. Talking to you, Amy Coney Barrett, John Roberts, and the rest of them. This appeal should be over. Petitioners denied the district court the opportunity to rule on their emergency motion in the first instance. That alone should be enough to terminate this appeal. They're done. But the Supreme Court, in their insanity, has reversed our unanimous judgment. And so this appeal must now proceed. And so, because I've been ordered to comply, I accordingly concur. Absolutely outstanding. It feels very good to have a defense of another good judge for once. I mean, the judge in Texas did everything by the book, did everything right. The other judges, Judge Zenas, Judge Boasberg, Judge Alsup, all of them, Reyes, the rest of them, are acting like lawless maniacs. And the Supreme Court isn't scolding them. Why is that? Because the Supreme Court is not acting in accordance with the rule of law. They are enabling terrorist gangbangers to get special privileges, due process premium, American plus. They get whatever they want. And if you sue because you're sick of your government telling you that you have to do things that are against your religion or against your freedom as a free person, they don't care. Take your sweet time. Everybody can get fired. You can go months or years without paychecks. Who cares? But if the Supreme Court sees any problems for illegals, all of a sudden they spring into action. So we're going to keep covering this one, my friends. Of course, the Fifth Circuit is going to now hear the case and set oral arguments and have to come up with some rules to give back to the Supreme Court to see if they're satisfied with it, because they couldn't do it on their own because they're too busy lecturing lower level judges who are just doing their job.
Let me know in the comments down below what you think about that letter. And more importantly, what you think about the judge. I give him a lot of credit for having the courage, not just to think the way he's thinking, but to actually put it on paper. And now we're talking about it. So let me know in the comments down below what you think, not just about what he wrote, not just about him, but also about our Supreme Court, which is getting a little wishy-washy. And that's an understatement. Also, the gentleman that created that video deserves a lot of credit. I can tell you it takes an immense amount of work to find that kind of source material. He did it. He made it available. I put a link to his YouTube channel down in the description below. I would recommend subscribing to it. It's a really neat, valuable YouTube channel, and he deserves all the credit in the world for doing the work to find that material. If you enjoy the video, give it a thumbs up. Want to see more like it, subscribe. And as always, until next time, God bless. Love you all.